Be ready. 5 seconds. Start. They were convicted by the trial court and have preferred appeals before the High Court and had prayed for grant of bail by suspension of sentence in terms of Section 389 of the Code of Criminal Procedure, 1973, within bracket, in short the code stop. The High Court primarily granted bail to each of the respondents on the ground that bail was granted during trial and their liberty was not misused. Stop. Further ground indicated was that there was likelihood of delay in disposal of the appeals. Stop. In the case of respondent Madhukar, in was stated that the evidence appeared to be scanty against him. Stop. Parachain. Questioning correctness of the order passed in each cases, learned counsel for the state submitted that there was large scale of manipulation of record resulting in manipulation of result of the candidates and each of the respondents had a definite role to play. Stop. Apart from the case where they have been convicted, large number of connected cases is also pending. The case of respondent Madhukar, 2 cases under the Prevention of Corruption Act, 1988, within bracket, in short the PC Act, were pending. In one case, the said accused had offered bribe to the investigating officer and was catch red-handed. Stop. It was submitted that the considering the gravity of the offense, the sentences were directed to run consecutive in terms of Section 31 within bracket 1 code. Stop. It was stated that High Court was misled in the case of respondent Janki, who made a false statement before the High Court that he had deposited fine amount, while in fact he had not done so, as would be apparent from the second order. Stop. It was essentially submitted that without indicating any plausible reason contemplated under Section 389 of the Code, the bail has been granted. Stop. The seriousness of the allegations, for which the accused respondents have been already connected, has been completed lost sight of. Stop. Parachain. Learned counsel for the respondent, on the other hand, submitted that the parameters of grant of bail and cancellation of bail are different. Stop. It was submitted that some of them they are elderly persons and have retired from service. Stop. It is not a case where any irrelevant fact has been taken into consideration. It is pointed out on behalf of respondent Madhukar that the said accused is stated to have centers round to cheats, which were exhibited. Stop. They did not any way establish the involvement of the accused in the alleged crime. Stop. That is why in case the High Court observed that the evidence in scanty. Stop. This appeal is directed against the order passed by learned single judge of the Andhra Pradesh High Court in a batch of petitions under sections 482 of the Code of Criminal Procedure, whereby the learned single judge has held that the drugs inspector appointed under Section 21 of the Drugs and Cosmetics Act, 1940 had no jurisdiction to launch prosecution under Section 32 of the Act for alleged offences said to have been committed under the Act in connection with manufacture and sale of drugs. Stop. Thanks for watching. Please like, comment and subscribe.